Hi, everyone. Thank you for attending today's CLE hosted by Legal Aid Services of Oregon's Domestic Violence Project. We appreciate your commitment to advocacy on behalf of low-income abuse survivors. And so today we'll be talking about one of the more common types of restraining orders that we refer to pro bono volunteers through the Domestic Violence Project, and that's the Elderly Persons and Persons with Disabilities Abuse Prevention Act, or EPPDAPA. So at the end of the presentation, I will email you the slides from today's presentation, along with EPPDAPA case summaries and additional resources created by our presenter, Trena Klohe, and our colleague, Deborah Doherty, both attorneys at the Oregon Law Center. We will also apply for CLE credit for today's presentation. So at this time, if you could put your name and your bar number into the chat, I will make sure that we report your attendance to the Oregon State Bar. This training is also being recorded and will be uploaded along with the other materials as a resource for you to refer to in the future on our pro bono volunteer website, which is probonooregon.org. Today's presenter is Trena Klohe. Trena is a senior staff attorney at the Hillsborough Regional Office of the Oregon Law Center. That's formerly the Hillsborough Regional Office of Legal Aid Services of Oregon. There, she focuses primarily on domestic relations and abuse prevention law for the last 2 decades. And before joining the Hillsborough Regional Office in 2002, Trena spent 3 years as an associate in the DC office of Latham and Watkins, a major international law firm. So I will now turn it over to Trena to get us started. Thanks so much.
Awesome. Thank you so much, Rebecca. And just for one quick correction, my first name is pronounced Trena. And
My
it trips
apologies. Thank you.
It's okay. It trips people up. Um, uh, Thank you, everybody, for joining in today. Hopefully, I will be able to get through this material in the hour and also address questions along the way. So if something does come up along the way, just put questions into the chat and Rebecca will let me know if we have questions coming in. Also, at the end of the slides, there'll be my contact information because I'm always happy to field questions about these restraining orders and other protective orders in Oregon. Obviously, Elderly Persons and Persons with Disabilities Abuse Prevention Act is a mouthful. So usually in my office, we just call it ADAPA, even though there are also P's in there. But my goals for today are really to just go through some basics of the restraining order elements, the relief available, and the procedure for getting and keeping these orders in place. So not likely to go deeply into enforcement, modification, or renewal issues, but hopefully this will lay a good foundation for assessing and litigating these cases. We also have a summary slide at the end with kind of the quick version cheat notes of what goes into these orders. We'll have a list of additional resources, both the ones that we're going to distribute later and some important resources online. And I've included some practice tips along the way that relate to some of the things that make ADAPAs a little bit weird and interesting. So with that, there are 3 basic sets of elements to these orders. Part 1 is you have to have a qualifying petitioner. Part 2 is there has to have been a predicate act of abuse, at least one, during the relevant time period. We'll go over all of these. And there has to be immediate and present danger of further abuse. And as with other restraining orders, the burden of proof is on the petitioner, and it's by a preponderance. So we'll turn first to what it means to be a qualifying petitioner for this kind of order. And it's kind of hinted at, right, in the title. One way to be a qualifying petitioner is to be an elderly person. That means 65 or older. Another way to be a qualifying petitioner is to be a person with a disability. And we'll go into that a little bit more shortly because there are some nuances there. And an additional category that is pretty unique to ADAPAs is that they can be brought by a guardian petitioner. That could be a GAL, that could be a probate guardian. Again, we'll go into more detail as we go along, but sometimes it means that you end up having kind of a weird three-way case between a guardian, the elderly person or person with a disability themselves, and the respondent. There are also some fun quirks in that an ADAPA order cannot be obtained against the elderly person or person with disabilities, guardian or conservator. But it is possible to get an ADAPA against a respondent who is a minor, but most likely a guardian ad litem would have to be appointed for them. And just a side note, because I didn't actually really internalize this information until I was preparing for this presentation, is that guidance on appointments of guardians ad litem is found in the Rules of Civil Procedure, or CIP 27. So for minors or incapacitated parties, there's a pretty good general set of rules. So turning to that question of who is a person with a disability. According to the ADAPA statute, right, it's a person described in ORS 410.715 or 410.0407. And what those categories refer to is either a person suffering from a traumatic brain injury or a person with a physical or mental impairment that substantially limits one or more major life activities. That is a whole complex range of possibilities there, partly because major life activities can include a lot of different things. The term major life activities is not defined in ADAPA itself, but there are definitions at ORS 659A.104. Those are referenced in this case, AKF versus Burdett, which helped clarify how this analysis should be done. And so relying on that statute, 659A, a person who wants to show that they are a person with a disability has to demonstrate that they do have a physical or mental impairment. They have to show that it restricts one or more major life activities. And then they also have to meet the standard of that it restricts those activities when viewed in comparison with most people in the general population. And that's helpful because major life activities can include eating, sleeping, sitting, socializing, working, and many, many other examples that are also included in the statute that case relies on. And then the definition of brain injury is a little more straightforward, but again, I would refer you to the statute when you are in doubt about this. A lot of cases, there's going to be no real dispute about whether the person does have a disability, but in some cases, it is going to be important to prepare argument on that issue. And so that's where my first practice tip slide comes in. If you anticipate that there might be any question about the person's disability, it's important at the very least to prepare your client to be able to testify about their traumatic brain injury or about the major life activities that they struggle with. Again, with some emphasis, ideally, on how this sets them apart from everybody who struggles with things from time to time. It is very helpful, certainly, to bring supporting evidence or documentation if that is reasonably available. Maybe that's medical documentation, maybe that is a finding by the government already that they are a person with a disability, um, and a trial memo that references the case law and statutes can also be useful if there is time. There's not always going to be time to cover all of these bases very thoroughly, but again, it's important to at least consider the possibility that a person's disability status could be in dispute. In my own experience, that's not often a hotly contested issue, and judges usually, I think, it's hard to generalize totally, but I think usually they accept a petitioner's word regarding their own impairments. I haven't seen a lot of credibility struggles over that in my own cases. But okay, so if we've established that we have an elderly person or a person with a disability, the next thing that has to be proven is that there was at least one incident of abuse within the prior 180 days. So a couple of wrinkles here are, what does 180 days really mean? And the other one is what counts as an incident of abuse. So the 180 days part is simpler, right? Because usually it just means what it says. 180 days looking back from the date of the petition for the restraining order. But much as with FAPAs under the Family Abuse Prevention Act, that 180 days is told if the respondent is incarcerated, so you don't have to count the time that they're in jail or in prison against those 180 days. You also don't have to count any period of time in which the parties were living more than 100 miles away from each other. And that's based on the principal residence of both the respondent and the victim or survivor of the abuse. Trickier issue is usually what does qualify as abuse. There are some forms of abuse listed in the ADAPA statute that are pretty straightforward, and then there's some of them that are really expansive and some that are just weird. So the straightforward list includes the ones here on this slide, right? Causing physical pain or injury by something other than an accident, right? Since these are cases that often involve folks with heightened needs for caregiving, abuse can include neglect that leads to physical harm. Likewise, abandonment or desertion by a caregiver or person owing care duties, and non-consensual sexual contact. And some of these overlap with abuse that you would recognize in a FAPA context or maybe in a stalking context. On the sexual contact piece, this is a little bit more broad than the FAPA definition about force or threat of force. This is less about force. It is just about whether the contact was consensual or not. So again, at least as a threshold matter, these categories are relatively straightforward. But then the weirdest one in the statute that I've never seen come up in practice is that there's a category of abuse related to sweepstakes promotions, which I don't know if those are even a thing anymore. But when the statute was enacted, there was clearly some concern about sweepstakes related scams on elderly people. But again, probably not going to have any actual relevance to the work you're doing on these cases. One that is relevant more often is about misappropriation or wrongful taking of money or property. Because again, like elder abuse could include forms of violence, it could involve sexual abuse, but also sometimes is just straight up stealing things from an elderly person or a person with a disability who is vulnerable to that kind of exploitation. Finally, there is a really, really broad category that often does come up in cases, at least that I see as well, and I suspect in cases that would be referred to volunteers. And as you can see, this is a lot of pieces contained in one phrase, right? One very long phrase, right? But derogatory or inappropriate names, phrases, profanity, ridicule, harassment, coercion, threats, cursing, intimidation, or inappropriate sexual comments or conduct of such a nature as to threaten significant physical or emotional harm to the elderly person or person with a disability. Um, I kind of think of this as shorthand in my own brain as the cursing at grandma clause. Um, and then the question usually ends up being is it just cursing at grandma, or is it something that, like, in the context of the cursing or whatever other comments or behavior, is it something that has a very significant effect or potential effect on the elderly person or the person with a disability? And so that's where you combine the inappropriate comments or conduct with that aspect of significant physical or emotional harm. And, you know, one of the examples that comes to my mind, because it got litigated pretty heavily in a case we'll talk about more, um, involved a situation between two neighbors. And essentially, the victim was subjected to a just massive amount of homophobic slurs by his angry neighbor. Um, it also involved like yelling in the middle of the night and like, sleep disruptions. But basically, it was more than just being rude to a neighbor. It was something that was triggering for anxiety, PTSD, um, because the victim was also someone who had been a past survivor of sexual violence, and so this was bringing some of that back. The pattern of behavior between these people was affecting his sleep and his health, and so those things could be documented in a way that go beyond just somehow trivializing the interactions as something involving just mere insults or swear words. But there are, I think, other situations where you might be able to link the obnoxious behavior or the obnoxious words, again, to someone's mental state and like anxiety, if they're feeling threatened, if something is maybe affecting their blood pressure. I mean, there are a lot of potential situations where you can kind of connect those dots between the speech or the behavior and the threat of harm. And both of those things have to be included in order to come within this definition. Um, because this paragraph encompasses both comments and conduct, right? As I highlighted all the different things that relate to speech, it's also important to consider the question of whether there is a freedom of speech component to this. And that was an undecided question until relatively recently. It was basically, can you issue a restraining order against somebody based exclusively on abuse that took the form of speech? And obviously, I've given the spoiler right up front. This does not violate the state and federal constitutions. Uh, this language in the statute is not overly broad. It does not require any kind of limiting construction. Um, but anybody who has worked on stalking cases might be familiar with something called the Rangel test that has kind of crept its way from criminal stalking cases into civil stalking cases. And from there, I see respondents' attorneys just throwing it out as an argument that they don't even really try very hard to make. But in FAPA cases and ADAPA cases, where they're basically just saying, oh, speech is involved, therefore you have to apply the Rangel test. And the Rangel test is really extreme, right? In the stalking context, it means that in order to count a communication as um, as a stalking contact, it has to be a threat involving um, imminent and serious personal violence. It has to be unequivocal, objectively likely to be followed by unlawful acts. So I guess it's 4 years ago now, the Court of Appeals did issue a decision in a case called IRS versus Hannington, where it held very clearly that the Rangel test does not apply in ADAPA cases. But it's important to be on the lookout because, again, often what I see in oral arguments in the courtroom or in, I think, both trial memos and appellate briefs is it seems like respondents' counsel often just throw in case law from all the different restraining orders anytime it mentions speech, and they just sort of assume that Rangel applies because speech is involved. So it's important to be on the alert for that. It's important to push back on it. And again, in the ADAPA context, we have this clear case authority that says Rangel does not apply. And that's very firm law at this point. It was taken up initially on review by the Oregon Supreme Court. I was fortunate enough to argue that case, but then instead of issuing an opinion, the Supreme Court decided to backtrack and declare that the whole thing was moot. So it was disappointing for me, but good for the client, and again, makes it very clear that the Court of Appeals decision in IRS versus Hannington is good law. But if anybody wants to hear me rant at much, much greater length about Rangel and all of our different restraining orders, pretty easy to goad me into that. But for now, we'll move on to the third element, which is immediate and present danger of further abuse. Statute is clear that this includes situations in which there has been recent threats of additional abuse, but it's not necessarily limited to that. To the best of my knowledge, there has not been a lot of appellate litigation on this issue, what immediate and present danger means versus the language in FAPA, for example, which requires imminent danger of further abuse at the time that a restraining order is issued. That requirement gets softened a little bit to reasonable fear at the contested hearing in FAPA cases. But for ADAPA, I think the basic idea is that danger has to be imminent, maybe like imminent plus. Again, those parameters aren't very well defined, but I think it's important to show that there is a risk of further harm that is pretty near and not particularly speculative.
Trena, we have a question in the chat. Is EPPDAPA considered a civil statute where the burden of proof is by a preponderance?
Yes. Thank you for requesting that clarification. Okay, so if you can meet that standard, right, by preponderance, which is pretty straightforward usually, then the relief available can include several different things. Certainly, basic no contact protections are available. ouster is available. So that means that for a victim who is living with the abuser, and either like is on, I guess, is married to the abuser or is on title to the property or is on the lease, right? That is someone who can oust the respondent from that shared residence as part of these orders. At a contested hearing, the court can then decide to have either one of them actually move out. But it does provide some ability to immediately remove someone who is a threat from the home in many circumstances. The court can order the return of misappropriated money or property if that's the form of abuse that had occurred. There's a nice catch-all provision for other relief that the court considers necessary. There's a provision for attorney fees at the contested hearing phase. And then also, even though EPPDAPA doesn't directly mention firearms, it's pretty well understood that gun dispossession and ammunition dispossession can come in under the umbrella of other relief that the court considers necessary. So, for example, if there is a situation where the elderly person or person with a disability has been threatened with a gun, or if their abuser is someone who does have maybe a large firearm collection and a history of instability or violence towards others, there's a pretty straightforward argument you could make that there is a heightened threat of gun violence in the case, and that therefore the respondent should be immediately barred from possessing firearms and ammunition while this order is in effect. So that's something that the judge has discretion to do as soon as they issue an EPPDAPA order. There are some other firearm wrinkles that I'll talk about in a moment, but I also wanted to flag that some of the things that you cannot do in the context of an EPPDAPA. And this is really in contrast to FAPA cases involving domestic violence. So in EPPDAPA, there's no way to establish temporary custody or a parenting plan, even if the respondent is a co-parent. In addition, unlike FAPA, EPPDAPAs do not have an emergency monetary assistance provision. So the court can restore money that's been stolen, but cannot necessarily order the respondent to just pay additional money to help the petitioner get through the crisis. But I promised more on firearms. This slide is pretty dense, and I think I'm going to skip ahead to the next piece and then skip back. But basically, if you look at EPPDAPA forms, right, there's this place on the document where a judge can order firearms restrictions. And they're in these two places. So 9A, right, just says the court orders respondent is prohibited from possessing firearms or ammunition. And that comes in under that other relief umbrella that I was just talking about. If the judge in their discretion thinks that firearms are a concern, they can put this in there. That takes effect as soon as the ex parte order is served on the respondent. Separately from that, there are also state and federal provisions that basically say that in certain domestic violence situations, someone can be prohibited from owning guns as well. And so this piece is the one that falls back under ORS 166255. So this applies in EPPDAPAs and other forms of protection orders as well. But the basic idea is that instead of just ordering gun prohibitions at the time that the order is issued. There are prohibitions that go into effect if certain other things are also in place. So one condition is that the order has to have been issued or continued after a hearing where the respondent had actual notice and an opportunity to be heard, right? So basically, this happens after the contested hearing, or the order was issued, continued, or it remains in effect by order or operation of law. And that is a situation where, say, a respondent is served with an ex parte order. They have 30 days to request a hearing. If they don't request a hearing, then the restraining order stays in place by operation of law. So they had a chance to have a hearing, they didn't use it, but this gun restriction still kicks in. But there are two other pieces as well, right? It has to be an order that restrains the person from stalking, intimidating, molesting, or menacing an intimate partner, a child of an intimate partner, or a child of the person. And so that means that in the ADAPA context, this will only apply in cases involving certain relatives, right? So it's a subset of the full universe of potential ADAPA cases. And there also has to be a specific finding that the respondent is a credible threat to the physical safety of the relative, right? The intimate partner, the child of the intimate partner, or their own child. So again, it's a bunch of little parts that come together. But if those things are in place and if the necessary findings are included, then this prohibition comes into place sort of automatically. Though what it means in practice is that the judge, upon request, fills out these 9B findings on the form, right? That there's a qualifying relationship, that there is a credible threat. And if those things are in place, they'll initial 9B and also attach a kind of a supplemental order that spells out the details of the firearms surrender. And the mandatory surrender, this didn't make it into the slide, but the mandatory surrender piece comes from ORS 166-256, which basically just fleshes out more details related to the prohibition. Again, I'm going to flip back one more time. The prohibitions in ORS 166-255 as cited here. So just if you look that up, keep reading and you'll see more about the mandatory surrender provisions. It took me a while to parse all of these things out, but I think the short version is really that you can do 9A and or 9B, and by you here I mean the judge, but basically the judge has discretion to prohibit firearms possession right up front, or if the judge makes the qualifying relationship and credible threat findings, then firearms prohibitions will flow automatically from that once the respondent has used or waived their opportunity to be heard on the order. Okay, so from there, even though I've talked about this a little bit in connection with the guns, I wanted to give the overview of the actual process, right? Again, similar to FAPA procedures, especially. The first step is an ex parte petition by the elderly person or the person with a disability or a guardian petitioner. And a fairly recent change in the statute allows the petition to be filed where the abuse occurred, right? It can also be filed where petitioner resides or where respondent resides. Sometimes this is all the same county, sometimes it's 3 different counties. There are variations on that. But it is now very clear that venue in these cases can arise from residents of either party or from where the abuse took place. If an ex parte restraining order is approved, it's issued with an expiration date of 1 year. When that order is served on the respondent, it takes effect, and the respondent will then have their 30-day window to request a contested hearing. And the contested hearing is often where we come in, right? Where we're asked to look at a case and then litigate it, people. There are, again, some additional procedural quirks. And really, ADAPA has lots of interesting little rabbit holes. Thankfully, there's not always an occasion to jump down each of those rabbit holes, but they're there. And so one is that in cases with guardian petitioners, right? So we have a probate guardian or a guardian ad litem who's been appointed to bring this case on behalf of an elderly person or the person with disability. That elderly person or person with a disability, right? The survivor of the abuse is entitled to notice of the case, and they're entitled to participate in the case and possibly object to the order, even if their guardian thinks they should have it. Another fun quirk that, again, is, I think, totally academic is special service rules related to the imaginary cases that involve sweepstakes. More pertinently to the work that we do is there are some special rules about the conduct both of ex parte hearings and merits hearings. So at the initial ex parte hearing, where the court is trying to decide whether to issue this order at all based on a prima facie case, that prima facie showing can be made by the survivor themselves, right? The elderly person or the person with disability. It can be made by the guardian or guardian ad litem. It can be made by witnesses to the abuse. It can be made by APS investigators. So I think the main idea there is that people who are concerned about the elderly person or the person with a disability can are sort of encouraged to come help make that showing. It doesn't necessarily have to come from the survivor himself or herself. Though without the survivor's cooperation, it's going to be harder to make a case at the contested merits hearings, right, if it's requested by the respondent. But the statute is clear that those hearings can be held in person or by telephone. The statute also specifies that the court should exercise its discretion to protect the elderly person or person with a disability from traumatic confrontation with the respondent. I'm not personally always sure exactly what the legislature had in mind with that, but some of it may be as simple as asking for permission to have the client testify from counsel table, for example, so that they don't have to look their abuser right in the face, right, eye to eye. There may be other ways to kind of help shield the survivor as well from additional trauma. There's certainly pretty standard options that courts are used to exercising to help keep the parties from like leaving the room at the same time. Usually the survivor can leave first, but there may be other creative ideas that you have, and if they make sense and you can still present your evidence, then please do get creative and ask for them. Make sure that you're talking to your clients about their concerns and their needs so that you can see if it's possible to address those in a way that still allows you to present information that's consistent with the rules of evidence. So one of the other big rabbit holes here that can have some practical impact involves cases where there is a guardian petitioner. And again, this may be, for example, an elderly person who is under a conservatorship. It might be a child who has had a guardian ad litem appointed for them, typically a parent. But it is always going to be important to be very clear in your own mind and clear in your communications with the survivor and with the guardian about who your client is and who you take direction from. And of course, this also ends up touching on complicated capacity issues sometimes. If you have a survivor of violence, the elderly person or person with a disability with limited capacity. And I certainly don't have all the answers, even if I made up a hypothetical around this right now. But I think it's important in those cases to certainly take a good look at the RPCs on the rules about clients with diminished capacity, where an important theme is always to treat that client as normally as possible and take guidance directly from them as much as possible. And so sometimes that means that you have to do kind of a delicate dance with a guardian who may want to have more say than they're entitled to. If the person, so if the survivor client has their own point of view on something. Tied into that, there is a section of EPPDAPA itself, and this is ORS 124.0107. And that's what I touched on very briefly earlier, where the elderly person or person with a disability has the right to notice of the proceeding if it was brought by a guardian. They have the right to their own counsel, right? So they have the right to contact or retain counsel. They have the right to file objections, request a hearing themselves, present evidence, and cross-examine witnesses. So even though it is super awkward, there's at least a theoretical possibility that you might have a case where there is a guardian petitioner who has brought the case and, has some amount of court-appointed legal authority to act for the elderly survivor or the survivor with disabilities, but where the abuse survivor themselves might be retaining separate counsel and has a totally separate agenda. So that's why I also mention RPC 4.2 about the rules about communication with represented parties. And if you're dealing primarily with a guardian, but the guardian and the elderly person and person with disability are not in alignment, right? There's going to be a challenging situation about whether there's a conflict of interest, about how communications need to be channeled, whether you have to direct certain communications to counsel rather than the survivor themselves. And there are also cases where it's actually just not that big of a problem because the guardian and the survivor are in alignment, and maybe the guardian is taking an important role in facilitating communications that are otherwise appropriate with the client with diminished capacity. But because there's at least an opportunity to get really tangled up in this, because there are some potential pitfalls, it is really important, I think, anytime that a guardian petitioner case is presented to you, that you review these rules and make sure that you are confident in the lines that you're drawing and comfortable with how you're proceeding if you're going to move forward with the case. Okay. So now we've touched on the ex parte hearing, we've touched on the contested hearing, the order's now in place. And I told you I wasn't going to go much into detail on what happens after that, but did want to at least flag it, right? That, as mentioned, these are orders that last for 1 year unless the court terminates it at the contested hearing or unless the court grants a renewal for a second year. And for those who have worked with FAPAs before, you'll recognize that this is shorter than the 2-year term that now applies in FAPA cases. And it is certainly different than stalking protective orders that have no expiration date at all. The standard for renewal in these cases is good cause shown. It is clear in the statute that this does not require any finding that there's been a further act of abuse. So in other words, you can renew an EPPDAPA order even if it has never been violated. That renewal has to be filed before the 1-year expiration date, or it's going to be too late. But beyond that, good cause is not defined in statute or case law in any serious way. And so you've got a lot of room to make creative arguments about your client's needs on that. Finally, violation of an EPPDAPA order is something that's supposed to prompt a mandatory arrest by law enforcement. As with FAPAs, those are cases that are punishable by contempt. So they're not technically crimes, even though they proceed much like crimes. So again, FAPA and EPPDAPA are similar in that way. Stalking cases involve much more severe punishments for violation because those can be misdemeanors or felonies. So with that, here is the main summary, right? So as we've gone over, the petitioner has to be an elderly person, a person with disability, or a guardian petitioner, all as defined in the statute. You have to have at least one incident of abuse within the last 180 days, either actual 180 days or 180 days told by the 100-mile or incarceration rule. And you have to demonstrate immediate and present danger of further abuse. Relief can include no contact, ouster, gun dispossession, attorney fees, but not custody and parenting time and not emergency monetary relief. It's a 1-year duration, renewable for good cause shown, and there is a mandatory arrest for violation. So hopefully, if you have no other cheat notes, hopefully this slide will be helpful to you. But there are more in-depth resources as well. I just gave a little snippet here of the comparison chart prepared by LASO and OLC. So current as of about a year and a half ago, but if you really want to get into the nitty-gritty of how EPPDAPAs compare to FAPAs and stalking protective orders and sexual abuse protection orders, and then also a few more obscure protection orders primarily related to firearms. There is this very detailed chart that you can download on OregonLawHelp.org. So it will give you references to the relevant statutes. It will compare the duration of each type of order. It goes into the filing process for each type of order, the contested hearing process for each type of order, the relief available in each type of order. So and it really drills down. It's a really long document, but there's lots of good information in there. And certainly if you are trying to get some clarity on how each piece works, or if you're trying to help a client determine what's the best fit for their needs, then that is a really, really great resource to keep in mind. Sometimes a person could be eligible for three different
Hopefully
things
no
at
one
once.
asks any questions.
Oh, hello. Um, in addition, on the firearms piece specifically, there is a bench sheet that is linked here. Um, again, you can go into a wonderful rabbit hole trying to parse all of those different overlapping pieces. Usually it's just going to be handled by the judge, but this is a place to go to understand those pieces better and understand what the judge is working from when they are figuring these things out. Finally, this is getting pretty old now. There is a combined FAPA and ADAPA bench guide that is available on the Oregon Courts website. So that link is here as well. The ADAPA portion of that bench guide begins at page 67 of the document, which gives you a clue as to how large it is. But has good information and references to some of the relevant case law. As Rebecca mentioned, we'll also be distributing our own summaries of cases in ADAPA land. Thankfully, I guess, thankfully on one level, there is not a ton of case law on ADAPA, so it's pretty easy to find and review because you just do a search on the statute. As opposed to FAPAs and stalking protective orders, where those are litigated on appeal pretty constantly, and so the landscape is often shifting in large or small ways pretty frequently. But ADAPA has been a little bit more stable. But what that also means is that there are a lot of questions that don't necessarily have definitive answers yet, but that gives you a little bit of room, hopefully, to be creative in your advocacy and focus on really telling compelling stories about our clients, what they've been through, why they need to be shielded from further harm. So that was all of the material that I had. So I would welcome any additional questions that folks have today. And again, if anyone who wants to talk about this at another time, welcome calls and emails. Always happy to talk about restraining orders.
I have a question, Trina.
Yeah,
Do you think judges have discretion to renew an EPDAPA for longer than a year?
I've not thought deeply about that, but I assume no. There's certainly no explicit authority to do that, and I would need to go and double check whether the renewal statute says anything about 1 year or just kind of lets that be implied.
I had a judge do it. So,
Oh,
judge is actually the one at ex parte, and then at the contested hearing, the second judge declined to, like, I flagged it and stuff,
hmm
because I just couldn't really find, as you say, explicit authority for that.
hmm
Found more like the opposite. But then the second judge also kept it at like a 2-year order on the renewal. So,
There is no rule that says you can't have dogs in baseball, right? I think it's maybe along those lines. It might also be that um, I think judges as well as attorneys, I think often put ADAPA and FAPA together in their
Mhm.
minds. And so if one thing changed, then they kind of spread it to both. But, you know, if in fact the statute is silent enough on this, then the judges can do what they want unless and until someone appeals.
Yeah, that's kind of what one of them said. So, thanks.
Sure.
Trina, another question in the chat. What arguments can you make if petitioner seeks to appear by phone at the merits hearing and the defense objects that denies due process? There's no constitutional right to confront in a civil case?
I think that probably would be my argument and just the straight up statutory argument that it says that the person can appear by phone. However, I would be worried about whether having that fight or making the phone appearance generally would diminish my client's credibility with the judge in any way. Because often showing up in person does help just make you more real to the court. I mean, obviously, judges do a perfectly fine job a lot of the time with remote hearings, whether that's phone or video. But if you really want to be able to pull on someone's heartstrings, which is partly what these cases are about ultimately, then um, you know, having your client show up in person, even though they're maybe scared and maybe frail, it's going to be hard on them, but it could be that much more compelling for the judge. So that was my long-winded answer, but the short one is you've got a statute to cite to, you have this is civil, not criminal to cite to, and then you just have to weigh the strategy.
Any other questions before we wrap up? You're welcome to unmute and ask that question or put it in the chat. I will also remind you, if you haven't already, please put your name and your bar number into the chat so that we can report your CLE credit on this. All right, seeing no additional questions popping up, thank you to everyone for attending. Thank you for volunteering with the Domestic Violence Project, and especially a big thanks to Trena for presenting today.
Thank you all for giving me the chance to talk to you about these cases.
Have a good afternoon, everyone.